At exactly 4:03 p.m., Senator Jeff Merkley reached into the inside pocket of his suit jacket and pulled out a small, well-worn copy of the United States Constitution, the kind printed small enough to fit in a breast pocket, but large enough in consequence to define the boundaries of American power, and as he opened it and read 5 words aloud, "No person shall be deprived," he set in motion an 11-minute exchange that would expose not a policy disagreement, not a partisan dispute, but something far more unsettling. The FBI director's fundamental unwillingness or inability to defend the very document he had sworn an oath to protect, revealing that the most dangerous threat to constitutional rights does not always come from those who openly reject them, but from those who claim ignorance, complexity, or jurisdictional distance when asked to defend them plainly. Cameras captured everything as the Hart Senate Office Building's Judiciary Committee hearing room seemed to grow. Heat of air with each passing second, the American flag standing directly behind the committee chair, like a silent witness to a test that would determine whether its principles were alive or merely ceremonial, while FBI Director Kash Patel sat behind the witness table in a perfectly pressed suit, posture confident, demeanor composed, buoyed by the fact that he had already spent more than 3 hours deflecting questions about FBI operations, staffing decisions, oversight failures, and controversial enforcement actions, using familiar bureaucratic language about procedures, interagency coordination, and ongoing reviews, surviving aggressive questioning by pivoting repeatedly to operational successes, arrest statistics, and assertions of institutional commitment to the rule of law. But Senator Jeff Merkley was not like the other senators Patel had faced that day, because the Oregon Democrat brought to the moment a kind of authority that could not be brushed aside with talking points. He was a former nonprofit director who had worked directly on civil liberties issues long before coming to Congress, a legislative director who had helped draft bills protecting fundamental rights, and a lawmaker known throughout the Senate for using simple, direct language to expose officials who attempted to hide behind legal jargon or bureaucratic fog. And on this day, Merkley had prepared something uniquely disarming, something that would strip away all obfuscation and leave only the Constitution itself standing between Patel and accountability. The hearing had covered a wide range of FBI matters over the course of 3 hours, from counterterrorism priorities to domestic extremism to internal discipline. And throughout it, Patel had maintained his standard posture of guarded confidence, repeatedly insisting that the FBI was committed to constitutional principles while avoiding any direct engagement with what those principles required in practice. And Merkley had sat quietly for most of the session, reviewing his notes, occasionally glancing at the small Constitution resting on his desk as other senators used their allotted time, clearly waiting not for an opening but for the right moment to address what he considered the most fundamental issue of all: whether the FBI director would defend constitutional rights for everyone, or whether those rights had become negotiable depending on immigration status, political convenience, or agency jurisdiction. When Merkley's turn finally came, the tone of the room shifted almost imperceptibly. As he leaned forward and began not with an accusation, but with a lesson, his voice measured, deliberate, and unmistakably serious. "Director Patel," he said, "I want to discuss due process rights under the Fifth Amendment," holding up the pocket Constitution so that it was visible not only to Patel, but to the cameras broadcasting the hearing nationwide, explaining that he wanted to read the relevant text directly, not paraphrase it, not summarize it, but read the exact words that had been written in 1791, ratified as part of the Bill of Rights, and binding law for more than 2 centuries. "The Fifth Amendment states," Merkley read slowly, "no person shall be deprived of life, liberty, or property without due process of law." And when he looked up from the page, his eyes locked onto Patel's in a way that made clear this was no rhetorical exercise, emphasizing that these were not his words, not a modern interpretation, but the precise language Patel had sworn to support and defend when he took office. The setup was intentional and meticulous, because Merkley understood that once the Constitution itself was placed on the table, every evasive answer would sound hollow, and he followed immediately by laying out the allegation that gave those words urgent relevance, citing credible reports that hundreds of immigrants had been taken off the streets and deported to El Salvador without due process, without hearings, without access to counsel, without the opportunity to challenge their detention, and without any individualized determination of their rights, describing concrete actions rather than abstractions. Actions that, if true, would stand in direct conflict with the clause he had just read aloud. Then came the question, delivered plainly and without embellishment: were these individuals provided due process as required by the Fifth Amendment? A question so straightforward that it left no room for policy rhetoric or institutional deflection. And yet Patel's response immediately revealed that he was unprepared or unwilling to defend constitutional rights in clear terms as he replied, "Senator, I'm not a constitutional expert." A statement that landed in the room with an almost audible thud. Merkley cut him off instantly, disbelief sharpening his voice. "Stop," he said, leaning forward. "You're the FBI director. You took an oath to support and defend the Constitution of the United States, and you're telling me you're not a constitutional expert." The contrast devastating in its simplicity. The nation's top federal law enforcement official claiming insufficient expertise to answer whether the most basic constitutional protection had been violated, prompting Merkley to remind him that defending the Constitution was not optional or peripheral to his role, but central to it, embedded in the oath of office itself, and that he did not get to disclaim expertise when asked about due process. Patel attempted to retreat into familiar terrain, responding that the matter involved complex immigration law, but Merkley shut that door as well, holding up the Constitution again and stating flatly that it was not complex, reading the clause once more and asking, "Which word is confusing you, Director? No person. Due process?" The simplicity of the language rendering Patel's claim of complexity almost absurd, especially because the Fifth Amendment had been written deliberately in plain English so that ordinary citizens could understand the rights it protected. Merkley then narrowed the focus even further, honing in on two words that would become the crux of the extract. Ange, explaining in a tone that resembled a teacher correcting a student who should know better that the Constitution says, "No person," not "no citizen," not "no American." And asking Patel directly whether the word person meant only citizens or whether it meant every person within United States jurisdiction, framing the question as a basic test of constitutional understanding that Patel could not evade without openly contradicting settled law. Patel attempted another evasive answer, suggesting that different constitutional provisions applied differently. But Merkley refused to allow the abstraction, demanding a clear answer. Yes or no, does no person mean no person, or does it mean only citizens? Forcing Patel to confront the text itself, and when Patel reluctantly acknowledged that the language says person, Merkley immediately seized the admission, emphasizing that person means every person, citizen or not, documented or not, because the Fifth Amendment does not carve out exceptions based on immigration status. To eliminate any remaining doubt, Merkley introduced Supreme Court precedent, pulling out printed decisions, and citing case after case with precision, explaining that in Yickwo v. Hopkins in 1886, the court held that constitutional protections apply to all persons, in Wong Wing v. United States. In 1896, it explicitly affirmed that aliens within U.S. jurisdiction are entitled to Fifth Amendment due process. In Plyler v. Doe in 1982, it reaffirmed that undocumented immigrants are persons under the Fifth and 14th Amendments. And in Zadvidas v. Davis in 2001, it again confirmed due process protections for non-citizens, noting that over more than a century, the Supreme Court, across ideological lines and through justices appointed by presidents of both parties, had consistently held that due process applies to all persons, making this not a matter of interpretation or ideology but settled constitutional law. Armed with this overwhelming precedent, Merkley returned to his original question and asked again whether the Fifth Amendment had been violated when people were deported without due process, and Patel, trapped between denying documented actions and admitting constitutional violations, attempted to shift responsibility by claiming that such operations would fall under immigration enforcement agencies rather than the FBI, a move Merkley had clearly anticipated, as he immediately responded that constitutional violations are violations of federal law, and that the FBI investigates violations of federal law, asking pointedly whether Patel was saying that when constitutional rights are violated, the FBI considers it someone else's problem. Patel tried to hide behind jurisdictional language, but Merkley rejected it outright, stating emphatically that the Constitution is not jurisdictional, that the Fifth Amendment lies everywhere in the United States, and that the FBI's oath is to defend the Constitution, not to decide which violations are convenient to investigate, then driving the point home with a historical warning, explaining that the founders chose the words "no person" precisely because they understood that once rights become conditional, once categories of people are excluded, everyone's rights become vulnerable, citing the Japanese-American internment during World War II as a moment when officials claimed necessity and complexity to justify abandoning constitutional principles, a decision later recognized as a profound constitutional failure. Merkley's voice carried both anger and urgency as he told Patel that claiming not to be a constitutional expert and invoking complexity were the same excuses used throughout history whenever officials sought to avoid defending inconvenient rights, reminding him that as FBI director he did not get to plead ignorance or deflect responsibility, that his sworn duty was to defend due process for every person, not every citizen, not every politically convenient group, but every person. And as he held up the pocket Constitution once more, open to the Fifth Amendment, he emphasized that no person shall be deprived of life, liberty, or property without due process of law is not a suggestion, not a guideline, but the supreme law of the land, stating plainly that if Patel could not clearly commit to defending that right for everyone regardless of immigration status, then he was not qualified to lead the FBI. The stakes were unmistakable now, and Patel attempted a partial retreat by stating that the FBI operates within constitutional bounds. But Merkley cut him off again, pointing out that this was not what he had asked, repeating that the question was whether Patel would defend due process rights for every person. And when Patel finally said that the FBI would ensure due process in its own operations, Merkley repeated the phrase, "in your operations," highlighting the limitation and making clear that Patel was still unwilling to commit to defending constitutional rights when other agencies violated them. And when Patel fell silent rather than clarify, Merkley closed his folder with deliberate finality, stating that the Constitution is not divided by agency jurisdiction, that the Fifth Amendment does not include exceptions for immigration enforcement, and that if the FBI will not investigate due process violations because they are deemed someone else's responsibility, then it is not defending the Constitution but finding excuses to avoid it. In the minutes that followed, constitutional scholars, former prosecutors, and legal commentators would note that Merkley had exposed something deeply troubling, not merely a policy stance, but an attitude in which high-ranking officials claim ignorance, the Constitution they swear to defend, and the exchange would go viral, not because of partisan theatrics, but because of its clarity, because a senator with a pocket Constitution had demonstrated that when rights are under siege, the most powerful weapon is not rhetoric, but the plain text of the law itself, leaving one unmistakable message echoing from the committee room. In the United States Constitution, no person means no person, and those entrusted with enforcing the law do not get to pretend otherwise.